Good morning, everybody. My name's Arthur Rolston. I forgot to wear my tag today, and I will try not to bore you for the next couple of hours. So here we are, 12 days before the election. And if you guys are like me, I stopped reading the papers after, but I'm just tired about it. Two cases from this recent Supreme Court term involved ex-President Trump. In one, the court held that Colorado could not keep Trump off the ballot under Section 3 of the 14th Amendment. In the other case, Trump received some immunity from criminal prosecution for seeking to overturn the results of the 2020 election. I'm going to take those two cases in the order that they did. The first half of the class is going to be on the Colorado case and Trump versus Anderson, and the second half of the class will be on Trump versus United States. Now, I'm going to make a bet here that I'm going to think I'm going to win. How many of you have ever read Section 3 of the 14th Amendment? Slide. There it is. And I'm going to read it to you. I should get bigger text. This is the copy of the Constitution I had when I was in law school, and it had sentimental value. It stops in 1962, so I had to handwrite in a number of the events. Okay, Section 3. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid, comfort to the enemies thereof. But Congress may by a vote of 2/3 of each house, remove such disability. That is Section 3 of the 14th Amendment. Now, I'm going to start with some history to put all this in context. And the history begins with Lee's surrender on April 8th, 1865, which effectively ended the Civil War. On April 15th, Andrew Johnson of Tennessee became the 17th president of the United States following Lincoln's assassination. Now, you got to understand, Johnson was a pro-Union Democrat from Tennessee, which is why Lincoln put him on the ballot when he was up for re-election in 1864. Johnson hated the slave-owning planter class, but he also had an absolute disdain for the rights of African Americans. And by the way, Democrats and Republicans, the two main parties at this time were the Democrats and Republicans, but they were actually the inverse of what we think of today. Democrats, during the Civil War years, the Democratic Party opposed aiding blacks, favored states' rights, and sought a negotiated peace with the Confederacy over the Civil War. The Republican Party, which had been founded in the 1850s, was opposed to the extension of slavery and ultimately favored its elimination, favored a proactive national government, and supported federal government investing in infrastructure, especially the railroads, which the southern states with the Democrats opposed. Now, in the spring of 1865, Congress was in recess. The Constitution provided in Article 1, Section 4, that Congress didn't convene until the first Monday in December. So remember, this thing was written before there was any transportation. They needed time to get there. That changed, by the way, with the amendment adopted right after Roosevelt's inauguration and the 22nd Amendment. So Congress was in recess and wouldn't convene until the first Monday in December. So before Congress could meet, Johnson decreed a pardon for anyone signing a loyalty oath as long as they weren't a former leader of the rebellion. He also declared that the former Confederate states could re-enter the Union as long as their new leaders and legislators swore loyalty. So most of them formed state governments that responded to the former landowners, the planter class need for cheap labor. They passed laws that required former slaves to work for their landowners for minuscule wages, for year-long contracts, punished as vagrants anybody who refused. And these codes were designed to secure laborers to work for the Southern fields, maintain a whites-only policy for most occupations, and limited both mobility and economic opportunity for the former slaves. They became known as black codes. And many Northerners were incensed over this. They were angry that the Southern states were still dominated politically by the planter class that had brought on the Civil War. Now, it's important to know that when Congress convened that December, both houses were solidly Republican. Now, under Article 1, Section 5 of the Constitution, each house was, quote, the judge of elections, returns, and qualifications of its own member, close quote. And neither house permitted any senators or representatives from the former Confederacy to take their seats. And they maintained that policy until their states revised their state constitutions, extended basic rights to former slaves, repealed their black codes, and ratified the Reconstruction Amendments. Most members of Congress were moderate Republicans, but the leadership was more radical. And they were not prepared to confiscate and redistribute lands to the former slaves. But they insisted that the former slaves be treated equally before the law, have political and legal rights, have standing, and that the former slave power be destroyed. So in spring of 1866, Congress enacted sweeping civil rights legislation, which declared that blacks were citizens entitled to due process and equal protection. Another bill established and funded a Freedmen's Bureau that would help the former slaves by providing education and support. And a third law that was passed a little later in late 1866 divided the former Confederacy into 5 military districts that were occupied by the federal troops until Congress would permit the state to then come out of the Union. And that actually lasted for, well, all of the remainder of the 1860s and the early 1870s. In fact, another story is how it ended, which was the election of 1876. But the congressional leaders were aware that the Constitution did not include defining citizenship as among the powers delegated to the federal government. That was left to the states in the original Constitution. So because they were concerned that the first civil rights bill would be unconstitutional, Congress established a joint committee on the Constitution, members of both houses, to consider and draft a proposed amendment. Now, if you all saw Lincoln, I'm sure, raise your hands if you saw Lincoln, Spielberg's film, that was the 13th Amendment. But the 14th Amendment came out of this special committee. Now, historians have referred to the 3 Reconstruction Amendments, the 13th, the 14th, and the 15th, which granted suffrage to adult black males, as the Reconstruction Amendments. They actually called it the second founding. But the 3 Reconstruction Amendments did something unusual. They substantially increased the powers of the national government. All the amendments that were adopted before the Civil War that having to do with doing anything reduced federal power. Now, for the first time, constitutional amendments are actually increasing federal power because it's giving Congress the power to enforce the ban on slavery, to define and extend the rights of citizenship, and give adult black males the right to vote, whether the states liked it or not. Now, a little bit of, I got to give you some of my opinions. I think the current Supreme Court majority mostly ignores the ideals behind the Reconstruction Amendments. Rather, they interpret them based on 19th century, mid-19th century attitudes about race and rights in order to reach results that are consistent with their conservative views. Maybe next year, instead of doing just the cases, I'll do one class on the concept of originalism and why it's neither original nor historical. Okay, let's talk about the proposed 14th Amendment that emerged from this committee. It was largely drafted by Ohio Congressman John Bingham, an amazing guy. And if there's a book on him, if you ever want to read it, he's been called the second founder because he's responsible for the second sentence of the first section of the 14th Amendment, which I'm going to read to you because I think it's really important. Here's what he came up with. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States in the Constitution. No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's the first section of the 14th Amendment. And since the 1960s, it has been the foundation of civil liberties in the United States.
Why couldn't that apply to women?
Another class. The short answer is they didn't think women should do that. That's the short answer. But I'm not gonna talk about that. I could do a whole class on women in the Constitution. Okay. So, that's really, I was an intellectual historian and I was a legal historian because I taught the constitutional history classes at UCLA. I did lecture classes on pre-Civil War America, and I taught seminars on colonial and pre-Civil War America, but I did not write a dissertation on women's history. I wrote it on state constitutions, which is really boring, but it got me through. You have to realize I started grad school when I was 58, so it's a second career. Okay, the first, as adopted, the 14th Amendment has 5 sections. The 5th section gave Congress the power to enforce the first 4. The first section I just read to you. It guaranteed birthright citizenship and equality before the law. The second section ended the 3/5 rule. Remember the 3/5 rule? Before the Civil War, slaves counted as 3/5. Well, it eliminated it now because they're citizens, they're counted in full. But it provided that a state's representation in the House of Representatives would be reduced proportionally to the extent that any adult males were denied suffrage, except for commission of a crime or because they were insurrectionists. It was a backhand attempt to induce the southern states to give blacks the right to vote. Why did they do that? Well, one is they figured they were all Republicans in Congress. Remember, the southern states weren't sitting there allowed back in Congress. And they figured that all these male blacks are going to vote Republican because Republicans ended slavery. They were right. But they weren't prepared at that time to directly extend the right to vote, because the Constitution, as you recall, it provides that states run elections and determines who can vote. If you can vote for the most junior house in the state legislature, you can vote for members of the House of Representatives. And remember, in the Constitution at the time of the Civil War, only the House of Representatives was directly elected by people. Senators were picked by state legislatures, and the president was elected by an electoral college whose members were selected by state legislatures. There was no requirement that they do so based on popular votes. So that's what Section 2 is. It was a backhand attempt at suffrage. Now, 4 years later, they changed their mind, and the 15th Amendment did it. And by the way, to answer your question, the reason the 15th Amendment is limited to males is because Frederick Douglass, who was the prime instigator of the 15th Amendment, along with the senior Republican leadership in Congress, knew that they didn't have the votes to approve a menu that gave women the right to vote. Now, just for a little bit of a digression here, the first state to give women the right to vote was Wyoming. in 1889. And the reason they did it is because there weren't any women in the state and they wanted them to come. So if we give them the right to vote, maybe they'll come. California gave women the right to vote in an election in November of 1911 when they adopted, Hiram Johnson's progressive program. All of those progressive amendments passed by landslides, except the women's thing, which given women the right to vote, which barely passed by 52% to 48%. And it wasn't until 1920 that Congress approved the amendment giving women the right to vote. So that's that story. Section 3 of the amendment was designed to prevent the planter class from regaining control of the government. If you recall, or if you don't, before the Civil War, they talked about the slave power. And they did so because this slave power, controlled the national government. Between 1828 and 1860, every president was either a Southern slave owner or a Northerner who was sympathetic to the Southern point of view. And Andrew Jackson, elected in 1828, served 2 terms. Martin Van Buren, who followed him, was a New Yorker, but he wasn't prepared to outlaw slavery. And actually, he wanted the government to rule the court to rule the other way in the Armistead case. If you ever saw that movie, it was accurate in that sense. Tippecanoe and Tyler too. William Henry Harrison was a Southern slave owner. John Tyler was a Virginian slave owner. James Polk was a Tennessee slave owner and a protege of Andrew Jackson. Zachary Taylor was a Kentucky slave owner. Millard Fillmore, who was his vice president, was a Northerner but sympathetic to Southern slave owners. Franklin Pierce was New Hampshire but sympathetic. Buchanan was a Pennsylvanian, sympathetic. The Supreme Court, 6 of the justices were Southern slave owners.
Wow.
And in Congress, they had enough Senate, with the 3/5 rule, they had lost control of the House finally in 1848 or 1846, but they retained their power in the Senate. And under the Senate filibuster rule, they were able to prevent any law getting passed that was contrary to their interests. So when Lincoln got elected, they taught the slave power, the slave interest had essentially a veto power over the national government. And the third section of the 14th Amendment was designed to get rid of that. Okay, and the 4th section basically disavowed Confederate debt and said the slave owners were not entitled to any compensation for the loss of their slaves. And remember, at the time of the Civil War, the assessed value of Southern slave exceeded the assessed value of all Northern factories and all Southern real estate. I mean, that represented the bulk of Southern of national wealth. So in any event, so there you have it. So what happened? Did the 3rd section actually disqualify anyone from holding federal office? Not for very long. President Johnson basically gave a pass to anyone who would sign a loyalty oath and swear loyalty as long as they weren't part of that Southern leadership. In 1872, Congress approved, quote, full and absolute pardons and amnesty for the offense of treason during the late Civil War with a restoration of all rights, close quote. That's in 1872. Even Jefferson Davis got a pass. Remember, he had been Secretary of War, he was a senator, so he'd sworn to uphold the Constitution, and then was President of the Confederacy. He was arrested in May of 1865, indicted for treason by a federal grand jury in Virginia in 1866. He got released from custody in May of 1867 and never spent another day in either jail or federal court. Davis's trial was postponed by the government a number of times, and in November 1968, they canceled the trial date without setting a new one, and the government agreed they had no intention to proceed. And by the way, Jill Lepore wrote an article on this. I got this from an article that was in the December 8, 2023 issue of the New Yorker. I know there's a lot of New Yorker subscribers among our group. So if you go online, you can pull up that article. It's December 8, 2023, and it's a really cool article by Jill Lepore. Who actually, yes.
Some former Southern generals become.
I'm going to get to that.
Okay.
Great question. Section 3 has little lasting impact. A number of former Confederate officials and military officers served in Congress. And I'll give you an example. You saw Lincoln. The vice president of the Confederacy was Alexander Stephens of Georgia. He had been in Congress in the 1840s. In fact, he was a freshman congressman when Lincoln was also a congressman, and their desks were next to each other, and they knew each other, and they had corresponded. That's why if you saw that scene in the movie Lincoln, Lincoln is talking to Alex and calls him by his first name because they knew each other. Joseph Wheeler, who had been one of the leaders, generals in charge of the the Confederate cavalry after J.E.B. Stuart was died, he had resigned his commission as a U.S. Army officer when his state seceded and became a Confederate general. He would then be readmitted to the U.S. Army in the late 1870s, and in the 1880s, he served 4 terms in Congress. And that's just 2 examples. So what about Trump? He was impeached by the House over his attempts to overturn the 2020 election, but the trial in the Senate occurred after he left office. The Senate refused to convict him on the votes of all the Republicans, except Mitt Romney, and Mitch McConnell acknowledged that Trump had instigated the attack on the Capitol, but he said he voted to acquit because Trump was no longer in office and supposedly would be subject to the law for his transgressions. Now, many Americans believe that Trump should have been convicted, also believed he should be disqualified. I put DQ'd here under Section 3. In September 2023, 4 voters in Colorado, 2 Republican and 2 independents, instituted a lawsuit in Colorado State Court to have Trump declared ineligible to run for president in Colorado's Republican primary. Their complaint alleged that Trump had sworn to uphold the Constitution. Remember, Trump was inaugurated in January 2017 and swore to preserve, protect, and defend the Constitution of the United States. So that was covered, and that he thereafter engaged in insurrection by attempting to overturn the results of the 2020 election. There was a 5-day trial in Colorado State Court, and Trump was declared to be an insurrectionist. The Colorado State Supreme Court said Trump shouldn't be on the ballot under Section 3, and Trump took an immediate emergency appeal to the U.S. Superior Court. Slide. Colorado, well, there we go. Colorado was not the only state that dealt with this issue. State trial courts in Illinois and Maine had made similar rulings that were on appeal. Complaints in 14 states were awaiting trial, and 18 states had already had trials that decided Trump could be on the ballot. So that's the status of the case when it comes before the Supreme Court in March of 2024. Actually, the oral argument was in February. And on March 4th, the Supreme Court announced its decision in Trump versus Anderson. All 9 justices agreed that state courts lacked the power to declare that a candidate for president was ineligible under Section 3. And one look at the map shows why this was necessary. This is the only result they could logically make. A candidate for president must be on the ballot in every state. And as a matter of fact, the last nominee of a major party who wasn't on the ballot in every state was, guess who? Abraham Lincoln in 1860. He was not on the ballot throughout the South. Even Teddy Roosevelt was on the ballot in all the states. I went online this morning because I was concerned. I asked Chat GPT and they gave me the wrong answer. Chat GPT said he wasn't on the ballot in Georgia and Alabama, but he got 19% of the votes in the Georgia election, and he got 12% of the votes in the Alabama election. So he must have been on the ballot, so there was a hell of a lot of write-ins. But so the president, a candidate for president, has got to be on the ballot in every state. And individual states shouldn't be making rules that are binding on the entire country. You know, we kind of agree that that's wrong. So to disqualify a candidate for president under Section 3 for president, that's got to be a national decision. It's got to be made at some level of the federal government, not the state government. You can't have states making contrary rulings about who's going to be on the ballot for president. And that's the president and vice president are the only offices that are in that case. So on March 4th, all 19 judges agreed that state courts lacked the power to declare a candidate for president ineligible. And in fact, in order to declare someone ineligible, you got to make two determinations. One, you have to determine what that person did. And secondly, you have to determine that what he did constituted insurrection or treason. And those are the kind of decisions the courts make every day. How many of you people have ever sat on a jury, criminal jury? You know that the judge tells you what the law is and who decides whether or not the defendant did it beyond a reasonable doubt? The jury. If there's no jury, the courts decide. That's what courts do in this country every day of the week. It's important to remember that. So for president and vice president, it's got to be a decision applicable to the entire nation. Now, the Supreme Court's accepting Trump's appeal said there was only one-ish question before the court, and I'll read it, quote, and this is in the order granting certiorari in the case. Did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential primary ballot? Question mark, closed. The answer to that is yes. They made a mistake. All 9 justices agreed. State courts should not be the venue that decides who is qualified or disqualified from being president. Some decisions got to be made by the national government to provide national uniformity. And if the Supreme Court had said just that, this case wouldn't be so important. The problem was that the unsigned per curiam opinion, it was understood to have been written by Chief Justice Roberts, declared just how the federal government could declare that a candidate for any federal office could be disqualified. Now, that wasn't necessary to decide in order to decide the case. That issue, how does a candidate get disqualified, was not briefed nor argued by the parties. Now, the opinion states that only Congress has the power to enforce Section 3 against a candidate for any federal office. By doing that, the opinion foreclosed the possibility of any litigation on this issue in federal courts involving any candidate for any federal office. And I'm going to point out where this basically is covered. The opinion foreclosed this litigation. So instead of a brief opinion supported by all 9 justices, which nobody would have objected to, you got 13 pages that provoked 4 dissents. Even this went too far for Justice Barrett. In 2 brief paragraphs, she notes that there was no need to decide how Section 3 should be addressed by the national government. Vacating the Colorado Supreme Court's decision meant that Trump would be on the ballot, and that issue would not arise again until after the election. Even if that's all they had done, to get him off the ballot, you would have had to have a case filed in federal court. Any of you ever litigated in federal court? It's not cheap, it's very complex, and it doesn't happen quickly. And there's all kinds of pretrial motions and briefing and interlocutory appeals. No way would any court case that had been filed after March of 2024 have been decided by November of 2024. It wasn't going to happen. So she said that he'd be on the ballot. And she said, quote, both the Supreme Court and the country would be better served had the Supreme Court, quote, turned the national temperature down, not up. Justice Sotomayor, writing for herself and Justices Kagan and Jackson, chastised the majority, the fellow justices, for, quote, trashing a fundamental rule of judicial restraint by holding that it takes an act of Congress to disqualify any candidate for federal office. So why did Roberts and the other four, Thomas, Alito, Gorsuch, and Kavanaugh, insist on going beyond what was necessary to? Because previously, Chief Justice Roberts had come out and said, you know, major best decided by by all the justices in short opinions. We don't need to have a lot of controversy. And he said this, and he remembered that Brown versus Board of Education, Warren didn't let that opinion come out until he had all 9 justices on board. Two possibilities. One is that Roberts, along with Thomas, Alito, Gorsuch, and Kavanaugh, wanted to protect Trump. They were convinced that Congress would never vote to disqualify him were he to win the election. A more generous supposition is that they wanted to pass this hot potato to Congress so the federal courts wouldn't have to decide. And that's what I think they did. Why they did this. This would be a losing proposition for the Supreme Court standing, no matter what, you know, it was kind of a lose-lose situation. Someone's going to be pissed at us no matter what we decide. But here's an example. I want you to imagine something. Imagine the 2 congressmen, one from Florida, aided and abetted the rioters who stormed the Capitol on January 6th. Imagine further that when running for re-election, petitions had been filed by California voters in California and by the few Democrats in Florida, objecting to Trump being on the ballot and attempting to disqualify him under Section 3. Imagine further that the liberal 9th Circuit here in California would have ruled that Trump should not be on the ballot, and that the conservative 5th Circuit in Florida had ruled that he could be on the ballot. Now, what happens when the circuits are divided on a question of law? The Supreme Court takes the case and has to decide it. And that's what I think was in the mind of the Supreme Court when he went so far. But he didn't have to. Why can't a federal court make a decision that applies to a congressman running for election or a senator? Why can't a circuit court in that case, because it's not going to affect what happens to another congressman in another state. So there's no reason at this time, without argument or briefing, to make a rule that the courts are not going to decide this issue. Only Congress is going to decide it, and it's going to have to be Congress for any federal office. And that's what Sotomayor and the three liberals said they went to, and even Justice Barrett said, you didn't need to do this. Judicial restraint. You should only decide issues that need to be decided in order to resolve the case. And that's the story of the Colorado case. Questions? Yes.
Yeah, so as the text of Section 3, as I recall, says that Congress can lift the disqualification
By 2/3 vote of each house.
But what you're just saying, and maybe I misinterpreted this, is that the court said, well, Congress should decide not if someone is disqualified to overturn that, but whether someone should be on the ballot. Is that, mishear that?
No, you didn't mishear it. And you raise a very, very interesting point. And that is that the drafters of the 14th Amendment never conceived that anyone running for federal office after the Civil War is ever going to be under this section, because nobody running for office is going to get so far as to, if you've been committed treason or was an insurrectionist. Our people are never going to allow someone like that to run for office. Well, they were wrong. Sue me. What can you do me? They were wrong. But that explains it. Because Congress, and actually in 1898, in order to promote national unity at the time of the Spanish-American War, Congress, by 2/3 vote of each house, passed a law that provided amnesty for anybody who was involved in the South during the Civil War to be free of any disability under Section 3 of the 14th Amendment. And that was in 1848. But that doesn't apply to Trump, because Trump was not then. It was some subsequent insurrection, which, quite frankly, the drafters of the 14th Amendment never thought about. Yes.
With your hypothetical with California and Florida, would the Supreme Court would it have made it to the Supreme Court before the next election? Would have they had to have taken the case?
They wouldn't have had to, but they probably would have. The normal procedure when you apply, the Supreme Court is allowed to choose what case it does. To give you an example, just so you'll get a sense of it, about 400,000 cases a year are filed in federal district court.
Wow.
About 20,000 cases a year are decided in published opinions by the 13 circuit courts around the United States. The Supreme Court takes 100 cases a year to decide. And the Supreme Court tells people what kind of case you should even bother, because it costs a lot of money and a lot of time to lodge an appeal with the Supreme Court. You don't just do it by saying, I appeal to the Supreme Court, take my case. You got to jump through a lot of hoops. There's a fairly significant filing fee. You have to, if you're indigent, you have to get a waiver of that. And you have to publish it. You have to provide a zillion copies. It has to be printed a certain way. There's a lot of hoops to go through. And so they tell people, look, here's the kind of cases we normally take. Cases that involve national importance. And one of the key things they tell people is to resolve a conflict among the circuits. That's one of the important things that the Supreme Court does, because they recognize that we should have national unity. And by the way, my third class is going to deal with that when we get to the homelessness situation.
I was thinking more of just the timing of making it through the circuit courts and whether they.
That's going to take a lot of time, but the Supreme Court can cut that time if they want to take an interlocutory appeal. You can say it's an emergency appeal. Like the Colorado case went up to the court on an emergency appeal. The states, the highest court in the state had ruled. You didn't have to go through any of the lower federal courts. Just bring it to us. We'll take it. It's important.
Arthur.
Yes.
So on the Supreme Court, taking a look at the Colorado case, the decision was about whether or not the states have the power to affect the national.
Does the state of Colorado have the right to declare a candidate for president ineligible to be on the ballot in that state?
So it wasn't whether or not Trump was an insurrectionist.
Well, that had been decided in the trial court. That issue had been decided in a trial court after a lengthy trial, and the Colorado State Supreme Court did not, affirm that. They assumed that was the case, and they honored the finding of the trial court. When it went up on appeal, it did not go up on appeal. The appeal was decided on the issue of the power of Colorado courts, not on whether the Colorado courts made the right decision that he was an insurrectionist. Their position was it wasn't for the Colorado court to decide that issue. Yes or no. So whether or not they were right or wrong on that issue was irrelevant to the decision. Because it starts with a much more fundamental level. Do they have the power to even decide that question? And the answer was no. State courts do not have the power to decide the questions that determine if candidates for president should be on the national ballot.
That's standing.
Now, standing is different. Standing is, the question is that standing? Standing is whether or not you have enough of an interest in the case to justify being a plaintiff in court bringing the case. And because now a Democratic voter may not have standing to contest Trump being on a primary ballot unless the state has an open primary. Because if the state has a closed primary, a Democratic voter is not eligible to vote in that election. Therefore, he has no interest in it and he has no standing. But a Republican voter does have standing. And that's why the case was brought by 2 Republicans and 2 independents, because Colorado allows independents to vote on either primary.
Arthur, could you flash up section 3 one more time? I wouldn't mind a quick reread of that.
There you go. Or elector for president, vice, or hold any office under the United States or any state, blah, 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 blah.
Hey, Arthur, is the definition of insurrection also part of section 3?
No,
No.
there is no, as I'm aware, there is no federal law of insurrection. And by the way, I skipped over, but one of the issues, problems in this case was there was no direct precedent involving section 3. The only case in the federal system with a published opinion involving section 3 came out of Virginia in 1870. A defendant in a criminal case argued that his sentence, his conviction and sentence by a judge in Virginia, the state judge, was illegal because the judge had taken an oath to defend the Constitution and in support of the Confederacy. And therefore, my conviction should have been thrown out because the judge was an insurrectionist and he shouldn't have allowed to be a judge. And the court had no problem saying, no, you lose. They're not going to set aside a judicial act by an aggrieved criminal defendant who was obviously guilty because somebody should have made sure that this judge had been declared to be, had been thrown off the bench. No one ever tried to throw that judge off the bench. So he was a lawful judge because, these provisions are not self-executing. This cannot be self-executing. You can't, because someone's got to decide, what did he do and was it an insurrection? Someone has to make that decision.
And that's what the Colorado court.
That's what the Colorado court tried to do for president, and the 9 justices agreed. No, when it comes to president, someone from the federal government has to make that call. States should not be able to decide who is or is not entitled to be president.
But the lower court in Colorado decided he had committed insurrection.
The lower court decided he had committed insurrection, and the Colorado Supreme Court said, based on that finding, he should not be on the ballot in Colorado. The Supreme Court said Colorado did not have the power to keep a national candidate for president off a ballot in Colorado.
So jurisdiction trumps.
Right.
No, that's the wrong way of looking at the case. I believe that the decision to say Colorado didn't have the power to do that was the correct decision. Whether or not someone is qualified to run for president must be determined at the national level. You can't have one state saying yes and another state saying no.
I understand that's one stream of thought, but the other stream of thought is how do we bring Trump to justice?
In federal court.
In federal court.
Yes.
That's the other stream.
And the second half of the class is going to deal with the whole issue of immunity.
Right.
While the Congress made a decision that he did In other words, that's why he was,
Impeach.
impeached.
The House made a decision, he did, the Senate didn't.
So that's the.
That's not why
Yeah.
impeach.
Now, when you talk about impeachment, there's a two-stage process. Impeachment is like an indictment. It's a charge made by the House of Representatives that someone should be tried for doing this act.
Right.
Now, in a criminal case, that trial is before a jury of his peers. For impeachment, at the federal level, that trial is before the United States Senate. And it requires a 2/3 vote of the Senate to convict. If he's convicted, he's removed from office and declared to be ineligible for ever running from office again. But it takes 2/3 of the Senate to convict. And that's what didn't happen.
How many votes on that?
All the Democrats voted to convict, plus one Republican, Mitt Romney. All the other Republicans voted to acquit, voted to acquit. And because the Senate was basically, remember, how was the Senate divided then? It was 50-50. Okay. All right, we're gonna take a short break for maybe 5 minutes. Can I, or do you need 10?
Good.
5-minute break, what's called a biology break.
There we go.
Okay,
And now I'll get the rest.
let me know when I can start. Don't want to start till we're ready. Okay. Now we got slideshow. There we go. Yay. All right. For the second half of the class, this is what's on the table. That is the definition of immunity. Keep it in mind, and I'm going to leave this up from, I only have 2 slides in this whole section. Keep this in mind while we're going through this, because it's really important. I'm going to give you a little bit of a warning. If you thought that the Colorado situation was complex, it was simple compared to the United States. And what you're going to get from me is a lot of quotations. The language in the opinion is really important to understand. And so you're going to get a lot of it. And I'll go slow and I'll repeat myself where you think it's necessary. Now, in Trump versus United States, the Supreme Court divided along the same 6-3 lines, held that presidents enjoy a measure of immunity from criminal prosecution when carrying out the official duties assigned to the president under the Constitution. The case involved Trump's alleged criminality in the various efforts to overturn the results of the 2020 election. The opinions, all of them together in this case, run 104 pages. It's not easy reading. I think after, when I finished writing this section and have gone through it 4 or 5 times, my first urge is to go get a drink. Robert's majority opinion runs 37 pages. Thomas and Barrett's concurring opinions total another 16 pages. Sotomayor's and Jackson's dissents add another 51 pages. Sheesh. I try and see both sides and look for what each side says that may be defensible, even where I might personally disagree. But I really, this time, they just got it wrong. It's a terrible decision, supported by a terrible opinion. I think it's right up there with the Dred Scott opinion, although I don't think we're going to end up with a civil war over the issue. I'm going to summarize the main points of the majority opinion and the dissents. You're going to hear a lot of quotes. The language is important, so I'm putting it out here for you so you get it. I'm going to point out the legal and historical inaccuracies and omissions, many of which are discussed in the dissents, but not all of them. Now, during the oral argument, Trump's lawyers conceded that Trump had no immunity for unofficial acts, but they claimed that he enjoyed absolute immunity against any criminal or civil charges arising out of any official acts committed while in office. And the question the court had to decide was, and here's the question, Did the circuit court err in holding that Trump had no immunity from prosecution stemming from his attempts while still in office to overturn the results of the 2020 election? That's the issue before the court. Justice Gorsuch said it was a major case, and during our oral arguments, he said, we are writing for the ages. It's not like this guy has an ego issue.
No.
Now, Roberts' majority opinion begins with a summary of the criminal charges against Trump for participating in the alleged conspiracies aimed to overturn the results of the election. And the particulars included conspiracies to 1, organize alternative slates of electors in 7 states. 2, using the Department of Justice to initiate bogus investigations of violations of election laws. 3, attempting to persuade the vice president to refuse to certify the results on January 6th. And 4, fomenting the disruption of Congress on January 6th to delay certification. Trump's alleged actions in furtherance of these conspiracies included knowingly making false claims regarding the conduct and results of the election, communications with state election officials attempting to change the results. How can we all forget his call to the Secretary of State in Georgia? Can't you just find me 11,000 lousy votes? The indictment also cited as manipulating the Department of Justice's leadership, his conversations with Vice President Pence, urging the attack on the Capitol to prevent Congress from certifying Biden's election. So that's what Trump allegedly did. And I was kind of amazed that Roberts laid it out that clearly. It's pretty clear from his own statement that this is pretty serious stuff. Now, Roberts argued that certain presidential powers rank above others because they are assigned to the president in the constitutions. This includes being commander-in-chief of the armed forces, negotiating and making treaties, appointing ambassadors, exercising the veto power, managing the executive branch, and granting pardons. These are basically his exclusive powers. And Roberts said they are, quote, unrivaled in gravity and breadth, close quote. In such cases, the president's authority is, quote, conclusive and preclusive, even if it's incompatible with the will of Congress, close quote. Under the Constitution, the court has the power to determine whether a specific action is within the scope of such authority. But once the court decides that it is within the scope of that authority, the president's discretion is absolute and, quote, cannot be subject to further judicial examination. Roberts' majority opinion states that such authority is, quote, rooted in the traditional separation of powers, close quote, but equally important is that such absolute authority is necessary to, quote, avoid diversion of his attention during the decision-making process caused by needless worry about possible adverse consequences from any particular decision. Close quote. Like I said, this language is there. Yes, sir. Do I have to? Quote. Equally important is the level of this high level of authority is, quote, to avoid this, quote, avoid diversion of his attention during the decision-making process caused by needless worry about possible adverse consequences from any particular decision. Close quote. In the majority view, the threat of criminal prosecution poses an unacceptable threat of, quote, intrusion on the authority and functions, close quote, such that the president, quote, would be deterred from taking the bold and decisive actions required of an independent executive, close quote. Thus, prosecution would, quote, distort presidential decision-making, close quote, which, quote, raises undue risks to the effective functioning of government, close quote. By subjecting a former president's official acts to scrutiny in criminal prosecutions, quote, the independence of the executive branch may be significantly impaired, undermined was the wording. Close quote. Thus, the public interest in a strong executive necessitates, he uses that verb, immunity, which is, quote, required to safeguard the independent and effective functioning of the executive branch and enables him, meaning the president, to carry out his constitutional duties without undue caution, close quote.
Whoa.
Yes.
Whoa.
But
Yeah.
how is that what he did, a constitutional
Oh,
or an official act?
we'll get to that. Basically, I'll get to that. The answer they would say is yes, when you hear what his definition of the official acts is, how wide it is. The president is not immune because he is president, he had to throw that in, but quote, to ensure that he can undertake his constitutionally designated functions effectively free from undue pressure and distortion. Oh, the poor guy. Now, the next section goes even further. It dictates when and how the trial court is to decide if immunity applies. Whether immunity applies must be determined as soon as practicable when the case is filed. And any appeal from that decision must be resolved before the case proceeds. I don't have quite a problem with that one. You can have a truncated appeal process. You should find out real quickly if this is the problem. And he says this is because the possibility of extended litigation may render him unduly cautious in the discharge of his duties. Close quote. No, you should know at the very beginning if there's any there.
Right.
So that's okay. But it goes even further. When deciding if a particular presidential action is official or not, to answer your question, there's almost a presumption that it's official because, quote, immunity extends to the outer parameters of the president's official responsibilities, close quote. The outer parameters, that is, it's official as long as it's not, quote, palpably beyond his authority. Close quote. In other words, what they're in effect saying is there's a presumption that whatever he does is right because he's the president. That is, it's official as long as it's not palpably beyond his authority. Thus, an action is not rendered unofficial because it violates, quote, violates a generally applicable law. Close quote. That is because it's a crime. Yeah, and I remember during the argument, and Sotomayor's talked about this, one of the questions she asked is, if the president, as commander-in-chief, ordered the assassination of his opponent,
Right.
would he be immune? And the lawyer said yes. As the trial, and it says, the trial court cannot inquire into the president's motive. To do so, quote, violates the separation of powers. If any specific conduct in question is within that, quote, outward parameter of official responsibilities, close quote, why the conduct was done is immaterial to decide if immunity applies. Dun, 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 dun. My notes here say, hum a few bars of Hail to the Chief. As they did in the Colorado case, the majority decided issues that were not necessary to decide this case. Apparently, they didn't trust the lower courts so that what they do is they spell out procedures and evidentiary rules that will basically give Trump as close to a get out of jail free card as possible. Just as Roger Taney tried to settle the slavery question once and for all in the Dred Scott case, the majority strives to decide every conceivable legal aspect of presidential immunity for all time and weighted heavily on giving the president a free pass. Yes.
Did they define what an official act is?
No, they did not. They said that's what the trial court's going to have to do, but they should use the language that I've got here in making that decision. In other words, if it's in the outer parameters or it's not palpably beyond, obviously beyond his authority, then it's covered. In other words,
I'm in my class still.
the risk of non-persuasion, lawyers
What?
Just lay down.
with the government. In other words, that it's assumed that what he's doing is okay unless you can prove it's palpably not okay.
Nah.
Justice Barrett and Justice Thomas filed concurring opinions. Barrett concurred that Trump enjoyed some immunity, but she expressly did not join in the parts of Roberts' opinion that dictated the procedures and the rules that would apply in the lower courts when they reconsidered the immunity question. She said, you didn't have to do this. It wasn't necessary to lay out the rules to be applied on remand.
Babykins.
The courts below
Babykins.
follow the law.
Baby
We have
girl.
federal rules of evidence that apply. It wasn't necessary to lay out the rules to be applied on remand. And she notes that these issues were neither briefed nor argued and were not necessary to decide the case. You know, kudos to her. She said, she may be an idiot when it comes to women's rights, but at least on this one, she had a possibility, part of it was right. She's still the sixth vote giving him that immunity applies, which I think goes too far. Thomas concurred entirely, of course. Thomas said that the indictment should have been dismissed altogether because the special counsel prosecutor in the case wasn't properly appointed. It's a technical argument based on his reading of the statutes, and my notes here say, don't ask. I didn't read those statutes. I'm not going to voice an opinion. I will note that not one of the other justices joined in this opinion.
69, are you cold?
And,
No.
and I also would point out that Trump's lawyers in argument, either in their briefs or in argument, didn't say that this was a reason that Trump should win. Yes, Mark.
I
get to that at the end. Can you count to 5? Wait, can you count to 5? Have you thought of hiring a hitman? Because other than that, there's not much you can do. And I'll get to that. Okay. However, I will point out the district court judge in Florida, who was a Trump employee, who was supervising the documents case. Remember all those documents found at Mar-a-Lago, dismissed that case based on this ground. The government's appealed it, so the Supreme Court will, as usual, have the final word. So let me talk about the dissents. Justice Sotomayor and Jackson. I can easily sum up their attitude. Majority, bullshit. In putting it right, granting any president immunity from criminal prosecution for violations of criminal law while in office is unsupported historically or legally, and it's terrible policy for the country. That's basically the points they made. Justice Sotomayor wrote that the majority, quote, invents an textual, ahistorical, and unjustifiable immunity that puts the president above the law, close quote. Immunity is inconsistent with the text of the Constitution, our history, and our understanding of the president's role in our government. It is, quote, unnecessary, misguided, and unprecedented, and will have, quote, disastrous consequences. By focusing on a supposed need for boldness, the majority ignores the equally important need for accountability and restraint. Her last words were, with fear for our democracy, I dissent. Normally, if you read enough of these opinions, you'll see that almost always the last line is, I respectfully dissent. The word respectfully was left out of this. And I think there's something to that. Justice Jackson wrote separately to explain just how the majority's decision fundamentally alters what she calls the, quote, paradigm of accountability, close quote, which underlies all of our laws in this country for presidents and what it means for our country. Quote, put simply, immunity is an exemption from the duties and liabilities imposed by law. That's why it's up here. It's a free ride to break the law based on who you are, to commit crimes with impunity, to be free from being held to account for one's conduct. A get out of jail free card. Immunity is not a defense. A defense says you did the act, but under the law, there are particular circumstances that make it excusable. Self-defense is an example. It's a defense. We don't have the right to kill people, but you have the right to defend yourself if your life is being threatened. That's the law. It's a defense. A defense means that the person did the act, but under the particular circumstances, it's excusable. Immunity means the law doesn't apply to me. As Justice Jackson noted, granting immunity says, quote, the king can do no wrong, close quote. Quote, the very idea of immunity stands in tension with the foundational principles of our system of government. It is a core tenet of our democracy that the people are the sovereign, and the rule of law is our first and final security. And just in case you were unaware of this, the criminal law is the bedrock of that security. A criminal statute means the people's judgment, acting through their representatives, that no one is permitted to commit a particular act that's declared to be a crime. Preventing criminal acts protects both the people and the government that serves them. Now, because individual liberty is at stake, the law and our Constitution and law provides criminal defendants with certain protections. The right to counsel, to compel attendance of witnesses, the privilege against self-incrimination, the prohibition against unreasonable searches and seizures, the protection of double jeopardy, the right to a jury trial, and conviction only on proof beyond a reasonable doubt. Our system of government begins with individual accountability. That's the foundation of the law. Each of us is answerable for our actions. And Justice Jackson points out the majority's ruling fundamentally alters this basis of a free society. Quote, now everyone is accountable except the president if the court says so. Close quote.
It's a wonder why no bells or gongs or anything were heard when they said to the court. So that means that the president can execute or, his rival.
People did say that.
I know that, but didn't that ring any bells?
Well, yeah. I mean, have you read the New York Times lately? I mean, the New Yorker. I mean, there's, the press. The liberal press is right there. Do you hear it from the conservative press? No, you don't. Yes.
Could Biden take out Trump and it'd be okay?
Yeah. Under this, he would have to say that under his commander-in-chief, if he did it after the election, he could make a better argument for it, because then he's going to come in. If he did it before the election, it would be unnecessary because he might lose.
Roberts is very concerned about his reputation and the legacy of the court. So why did he do this? Because he's got a black mark.
Because he's a Christian nationalist.
Yes, he is a Christian nationalist. Thank you.
Because I think that his concern for the reputation of the court only goes so far. And, I can give a lot of examples, where he's been totally inconsistent. I mean, one example, and I've used this before, there were two cases that came down in, I think it was 1917 or 1916, 1915. One was the case out of Alabama that said that section 5 of the Voting Rights Act, the pre-clearance requirement, was unconstitutional, even though it passed Congress 98 to 2 in the House and unanimous in the Senate. At the same time, he ruled that the Affordable Care Act, even though he thought it was bad policy, it was within Congress's power, and therefore the court shouldn't overturn it. If Congress, which has the power to enforce the 15th Amendment, says pre-clearance is necessary, and the majority of Congress, the overwhelming majority, unanimous majority, virtually unanimous members of Congress of both houses say it is, what's the difference between that and a 51-49 vote on the Affordable Care Act? That one's, Congress has the right to, there's no rhyme or reason for the inconsistency there, other than the fact that Roberts is, in my opinion, a hypocrite. Okay.
Excuse me,
Yes.
does this immunity ruling mean that
I don't know what it's going to mean because it hasn't been interpreted yet.
he can't be impeached?
No, well, I don't think it does, but, you know, that's a very interesting question. The court would probably say it doesn't apply impeachment. According to the court, impeachment's a political act, not a legal act. And it is a political act because it's voted by two political bodies. The Senate does not take an oath to enforce the law. The Senate takes an oath to protect the Constitution. But other than that, they can vote to acquit or acquit based or convict based on political considerations. They don't have to base it on the evidence. And there's no such thing as setting a decision of the Senate aside because it is unsupported by the facts. It's a political decision. Yes.
And maybe if you can, excuse me, get into this, but I'm trying to understand the mechanism. There's a bit of a carve out here that is nebulous as to what's official and what might be unofficial. And as I understand it, it's thrown back to, in this case, Judge Chutkin.
It's thrown to the trial court to determine based upon the standards and the criteria that Roberts has laid out in the majority opinion.
Which are not well defined.
Which are very well defined if you assume that Trump is immune.
In everything, but Jackson had refiled.
And there's a very interesting question.
Or maybe.
Yeah, and I say that at the end, that question hasn't been determined, and I'm not gonna say an opinion as to what I think the court's gonna do. I'm long beyond stating an opinion on what circuit courts, the DC circuit's gonna do. Right now, the DC circuit has like 18 judges, half were appointed by Trump or George W. Bush. The other half are appointed by Obama or Biden. And it depends which three are on a panel and whether or not the full court decides to rehear if they don't like the decision.
But that again could be thrown back up to the Supreme Court.
Absolutely, and I'll get to that. But let me go on here. The dissents point out why the majority opinion misstates or misapplies precedent and is contrary to our history. And I'll go so far as to call Roberts' opinion, much of it intellectually dishonest. And this is going to be a legal argument, so please bear with me. It understands the use of precedent. The majority cites and quotes a 1982 Supreme Court case, Fitzgerald versus Nixon. In that case, Colonel Fitzgerald had been a colonel in the Air Force, and as commander-in-chief of the Air Force, Nixon had ordered a restructure of the Air Force under which Colonel Fitzgerald lost his job because his position was eliminated. As a result, he was discharged from the Air Force and he was forced to retire before he wanted to, which cost him a lot of retirement money. He sued both the Air Force and Nixon personally for damages. He claimed that his firing, that the way it was structured was intent to get him out of the Air Force because he had testified before Congress that the restructuring was not necessary. He sued both the Air Force and Nixon personally. In a 5-4 decision, the Supreme Court held that Nixon enjoyed immunity from civil monetary damage claims predicated on his official acts while in office. It was a 5-4 majority, and the majority opinion states that the court, quote, balanced the constitutional weight of the interests served against the dangers of intrusion on the president's authorized functions, close quote. The majority opinion noted the possible need for unfettered freedom of action in the performance of his duties. And this is language that Roberts quotes repeatedly. What Roberts' majority opinion leaves out, what the majority ignored, was the Trump case didn't mention that the Fitzgerald opinion justified its decision of giving the president immunity against a claim for monetary damages because there were other more powerful constraints against presidential misconduct, including, and these are spelled out in the opinion of the Fitzgerald case, political fallout, what they call bad press, impeachment, and potential criminal liability. Adam Litvick in the New York Times called this selective editing that distorts the meaning brazenly dishonest. I agree. In the Fitzgerald case, Chief Justice Berger's occurring opinion stressed that the possibility of criminal prosecution was a much more powerful constraint than the possibility of monetary damages. Berger wrote that, quote, judicial intervention in the president's actions should arise when the public's interest makes it imperative to do so, such as when the president allegedly commits a crime. Close. That's not included, that's conveniently ignored in the Trump opinion. They don't mention that. Holding that Trump enjoys a measure of immunity from criminal prosecution or more generously undervalues the distinction between civil and criminal liability. In a civil case, especially a civil case for damages, the interests that are directly affected are those in the defendant's pocketbook and the plaintiff's pocketbook. Money from one is going to go to the other. That's a private matter. But criminal statutes protect the public as a whole by making everyone accountable. Now, I was asked, when I showed this to my daughter, she said, gee, what do you think would have happened to Nixon? Under the majority's opinion in Trump's case, Nixon would have been entitled to immunity from criminal prosecution for obstruction of justice. What was the obstruction of justice in the tape, the bullet? It was Nixon telling Haldeman and Ehrlichman to get the CIA to tell the FBI to put a lid on their investigation because it involves national security. That was Nixon's crime that got him to resign. And that was what Barry Goldwater said, if the impeachment comes to a vote in the Senate, Mr. President, based on the evidence I've heard so far, I would vote to convict. And that's when Nixon resigned. Neither Nixon nor anyone else at the time could have conceived that the Supreme Court would countenance presidential immunity from criminal prosecutions for unlawful actions, supposedly under the blanket of presidential authority. That's why this is such a bad case. Now, it's even worse. Supporting the decision that Trump could be from office, Roberts also relies on a concurring opinion in another case by Justice Robert Jackson. And he quotes extensively from Jackson's concurring opinion in the 1952 case, what's called the Youngstown Steel case. Some of us are older. I was 10 years old when this happened, but my dad told me about it because he was a political junkie. In 1950, the Korean War is raging. Truman ordered the army to seize the nation's steel mills when the steel workers went out on strike, claiming that as commander-in-chief, I need to assure that we maintain weapons production. Roberts quoted Jackson's language about how the president's constitutional authority over issues allocated to the president by the Constitution were unfettered, even if Congress disagreed. He pulled that line from Jackson's opinion. Now, one might properly surmise, if you were just reading the Trump case and you don't know your legal history, that Jackson's opinion was concurring in a result that gave the president authority to do whatever it was that was at issue. He would have been wrong. That case, the court held that Truman did not have authority as commander-in-chief to order to seize the president's steel mill. The court did not permit it, and so it's also intellectually dishonest, I think, to quote language from a concurring opinion that, in essence, rules against the position you're taking. Now, I have a little aside here. Justice Robert Jackson was a Democrat, and he and Truman had been good friends. In fact, Jackson really helped Truman when Truman was in charge of the Senate Committee on Corruption in weapons procurement during the war. And Roosevelt had put Jackson on the court. And in 1946, early 1946, Truman, the Nuremberg trials were about to get underway in Germany. And it was agreed that an American would be the lead prosecutor because the French couldn't do it, the Russians couldn't do it because they were victims of German occupation, and the Brits didn't want to do it because the Americans had more clout, and besides which, Churchill was out of power by this time. Clement Attlee Labor was in charge of Britain, and they didn't want to touch it with a 10-foot pole. So Truman asked Jackson if he would take a leave of absence from the court to be the lead prosecutor. Now, Jackson had this burning desire to be Chief Justice. And everybody knew that the current Chief Justice, Harlan Fiske Stone, was very ill. And in order to induce Jackson to agree to take on the gig, Truman said, and when you get back, I'll make sure you become the next Chief Justice. While Jackson was away in Nuremberg, Stone dies, and Truman appoints his buddy Fred Vinson as Chief Justice. Jackson was pissed and never talked to Truman again, and I think that may explain part of the reason why Jackson wrote this concurring opinion that basically said that Truman's got all these powers and they're really extensive and great, but you fucked up this time. So that's a little bit of a side history. Okay, back to the case. As for history now, we've talked about two of the precedents that he did. Roberts' majority opinion cites Hamilton's essays in the Federalist Papers that favors a strong unitary executive possessing ample power, which Hamilton believes is necessary for its effective government. You got to have a strong executive run at the top of the thing. And a lot of people said, no, having a single president is giving too much power to the federal branch, blah, blah, blah. Now, you have to remember that the Federalist Papers are basically a series of op-ed essays that were written during the last months of 1787 and the first 4 months of 1789 to 1788 to persuade the New York Convention to ratify the Constitution. That's why they're being written. And they ran the newspapers. Essentially, we would call them op-ed pieces. They're not necessarily reflective of what all the founders believed or wanted. But our conservative justices like using them all the time. Roberts referred to Hamilton's view in number 69 that effective government requires, quote, an energetic executive, close quote, who has competent powers to do anything and everything that might be needed as commander-in-chief of the armed forces, to direct relations with foreign powers, and to ensure that the laws be faithfully executed. What Roberts leaves out was what Hamilton says at the end of the three essays that deal with the executive. And I'm going to read this to you. We have now completed a survey of the structure and power of the executive department, which I have endeavored to show combines, as far as Republican principles will allow, all the requisites to energy, meaning the ability to get things done. The remaining inquiry is, does it also combine the requisites of safety? In a Republican sense, a true dependence on the people, a due responsibility. The answer to this question has been anticipated in the investigation of its other characteristics and is satisfactorily deductible from these circumstances. From his election of the president once every 4 years, from his being at all times liable for impeachment and trial in the Senate, dismissal from office, incapacity to serve in any other, and to forfeiture of life and estate by subsequent prosecution in the common course of law. Close quote. That was left out of the opinion. And that's what the dissent is really getting at. There's two sides to this. If there's two sides to authority. With authority comes responsibility. With responsibility comes accountability. So that's what's wrong with it. In a New York Times essay, right after the opinion came down the last day of the term, June 30th. On July 12th, James Booley, writing in the New York Times, said that the takeaway from Trump versus the United States is that, quote, Chief Justice Roberts, with the approval of his Republican colleagues, rewrote the Constitution to place the president above the law. Close quote. Time will tell if the opinion is as dangerous to our republic as the dissenting justice many Supreme Court commentators fear. If Trump is reelected, I personally believe he will read the case as a free pass for unprecedented presidential lawlessness. To get to the earlier question, what can we do? Other than vote early, and as Chicago's Mayor Daley said, vote often, not much. Change the slide. Amend the Constitution? It's never going to happen.
Never say never.
There we go. Now move that thing. You need. I need to see you show
Yeah.
what's up.
Anytime soon.
Okay, you can move that thing over to the side of it. Okay, there. If you look at these states, this is from the 2020 census.
Yes.
5 states have populations under 1 million, and they all get 2 senators. 8 states are under 2 million. They got 8. They each got 2 senators. Another 13 states are under 5 million. Those 13 states alone can prevent any constitutional amendment. And by the way, to amend the Constitution, it requires a 2/3 vote of the House, each House of the Senate and the House to approve an amendment to send it to the states. And it requires 3/4 of the states to ratify. Does anybody ever vote to give up power? So when people ask me, can we amend the Constitution? Yes, we can. Will we? No. It's politically impossible. And we complain about the Senate and the Electoral College because every state gets 2 senators. Senators in California represent gazillions of people. The senators from Ohio or Montana represent their mother-in-law. The answer is no. It takes the unanimous consent of the Senate to ratify the Constitution, to change the Senate. All states must agree to change the Senate. So is this ever going to happen? The answer is no. If they call a constitutional convention, first off, what do you think is going to come out of that convention? Again, represented by these states. What you may see in a constitutional convention scares the hell out of me. It may be Christian nationalism, it's a federal crime to burn the flag, and all kinds of crap. Prayer should be allowed in public schools, and blah blah blah. I mean, I can't imagine the crap that could come out of a constitutional convention, and possibly even get ratified. Although I would hope that the liberals, the blue states, would stand up and show some gumption, which they have not been prone to do.
What about using the Electoral College?
Equally bad. First off, what really is wrong with the Electoral College is every state gets the same number of representatives plus their 2 senators, which weights the Electoral College in favor of the smaller states. Will there be enough states? Will the states with holders of 270 votes agree to give all their votes to the winner of the populace choice? There aren't enough big states to have that happen. To get to 270, you're going to need a number of votes from the smaller states. So I don't think that's I think that's highly unlikely. I think the immunity case is going to have long legs. It's going to be appealed again to the Supreme Court, no matter what happens in the lower courts, especially when they consider the new indictment filed in this case. Especially, this is the case if Trump wins the election, then they never come back. Even if he loses the election, because I doubt the dissenters will ever get the 2 votes needed to overrule the case. They got 3, they need 5. That's the dean of my law school, Erwin Cherminsky, said, if you want to understand the Supreme Court, all you need to do is learn how to count. Because that's what it is. I'm going to close with this line. H.L. Mencken wrote that, quote, Americans get the governments they deserve. I really hope Trump loses and we never elect another like him. But unless a new 5-justice majority is willing to say they got this one wrong, I think we're going to be burdened with this case for years and years to come. Yes, questions?
I wanted to ask, taking a little different view on this, is haven't we seen the increase in presidential power? At the beginning of the country?
Oh, yeah, we have, and, you know, it started with the Civil War. People, I know one historian who said the kindergarten for the imperial federal government was the development of the West after the Civil War. Because the West was all run by the federal government. They weren't states yet. And the federal government got used to running things. And then there was the New Deal. And then we had as our country grew and became more and more complicated, you had more and more power at this federal level, which is right. When I was a kid growing up, people dressed differently, ate differently, and talked differently, depending on what part of the country you happened to be in. Now, we get the same McDonald's crap no matter where we go. We all wear the same clothes, because you go into stores anywhere they are, and it's all the same stuff. And most of us talk the way they sound on television, which is Southern California modern. That's just, yes, sir.
So maybe I'm a foolish optimist, but isn't there a history of conservative justices changing over the lifetime of their tenure?
There's a tradition, Mark asked a great question. Is there a tradition of conservative justices? A few have. Earl Warren is an example, it's a prime example. Souter is an example. Stevens, to some extent, is an example. But they were traditional conservatives. They weren't reactionary wingnuts. And there's a difference between a traditional conservative who reveres the Constitution and believes, G.K. Chesterton, who's a famous, some of you may know who he was. He was an English writer. He wrote the Father Brown Mysteries. He converted to Catholicism as an adult. And he wrote a series of books. And I remember I read them when I was in college, and it was one of them was a line from one really got to me. It says that democracy says, I don't ignore the good ideas simply because it came from my gardener. Tradition says, I don't ignore a good idea because it came from my grandfather or my great-grandfather. Democracy enfranchises the living, tradition enfranchises the dead. That was his line. And a true conservative follows that to a certain extent. But these guys aren't conservatives in that sense. I could say they're reactionaries. And there's a substantial difference. So to your question, Mark, do I think that there's possibly Justice Barrett is the only one? I mean, Justice Gorsuch is really interesting. His mother was Reagan's Secretary of Education, and she got nailed. The Supreme Court threw out all the stuff she tried to do, and he's been pissed ever since.
It seems like the one possible point of attack here is that immunity applies to official acts, right? Okay, and so do I understand right that in the documents case now, that's the issue that's being argued? And first of all, do I understand that right? And could that end up going up to the Supreme Court to sort of re-litigate?
Yes, it could in this sense. To the extent that Trump took certain documents down there while he was president, that would be an official act. But refusing to honor the subpoena and to tell the government what they were after he was out of office is not, I would argue, is not an official act. And I would argue that a reasonable judge should find it's not an official act. Are the judges reasonable and will they make that finding? I don't know.
Hey, Arthur, I want to go a little bit on the positive side of things, if I can.
Please go ahead.
Kamala wins. Then she can do whatever that was.
Yes, but I think that Kamala would take the point of view that she's not going to do anything she wants because she would agree that this is the wrong decision. And as president, her belief in the Constitution is that we are accountable. And I think she's that way. Yes.
What about adding to the Supreme Court? Is that possible?
Yes. Okay. The question is, what about adding to the Supreme Court, and is that possible? All the Constitution says in Article 3 is that there shall be a Supreme Court of the United States. This is Article 3, and I'll read the very beginning of it. By the way, this is the copy of the Constitution I got when I was in law school. It's not current, but this stuff hasn't changed. Article 3. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Constitution may from time to time ordain and establish. Congress has the right to say how many judges there are. And there's actually a history to that. It started with 7, then it went up to 9. Then in 1860, it went up to 10 or 1859, because California and Oregon were admitted to the Union, but there was this big part of the country that they couldn't get to. So they appointed a 10th Circuit to supervise them, because each Supreme Court justice was responsible for supervising the states within his circuit. And they appointed a guy named Stephen Field, who was a Union Democrat from California, to be judge. His brother, by the way, was a guy named David Dudley Field, who was probably the leading codifier of the idea of codes in the United States. And he was the extreme power lawyer of New York in the 1850s and early 1860s, until he made the mistake of agreeing to represent James William Marcy Tweed. He was on the wrong side of that case, and he lost his power. Stephen Field was his brother and became a Supreme Court justice. After Lincoln's assassination, the House voted to reduce the number of the Supreme Court to 7, and ruled that as justices resigned, they would not be reappointed until the number was down to 7. The reason is they didn't want to give Johnson the ability to appoint any Supreme Court justices. As soon as Grant was in office in 1869, the number went back to 9, because they had the Transcontinental Railroad. They didn't need a 10th district, and it went back to 9. And it's been 9 ever since. In 1936, in early 1937, fresh off his re-election, Roosevelt flew a proposal to increase the court to 16 members with everybody over 70 on retired status, so that they were supposedly work too hard. Well, 2 reasons why this failed. One is the judge says, no, we're not working too hard. And all the justices agreed they weren't working too hard. And the other reason is because the Roosevelt coalition was what? If you remember, it was the liberal North and the solidly Democratic South. And the Southern states were not willing to allow the Northerners to add more liberal judges to the court. So and quite frankly, the country wasn't ready to accept it yet. There was too much tradition that Roosevelt was playing with structurally that the country was ready for. And I think it'll hit the same wall today if Biden's idea of trying to expand the court, especially since it's clear he's doing it for partisan purposes.
Can we make the Supreme Court term limited?
No, because the Constitution provides that federal judges serve for good behavior, which is life. It would require a constitutional amendment to give them term limits. That's why federal judges either retire, go on senior status, or die. They can be impeached, yes.
In my book, democracy means proportional representation, like in Europe. And when I listen to this, I really wonder what are we? It's not a democracy.
Americans basically create differently. We do not have proportional representation.
Right.
And people are elected to office, not parties are elected to office. And the idea of European representation is really a 20th century phenomenon, and our traditions were in place for a century or more before that. And it's more on the English model, because remember, America was part of England, and our legal system was essentially an English legal system. And at the time the Constitution was written, it was the British system changed to do 2 things: to remove a hereditary aristocracy and to remove a monarch, and to the whole English system is based on the idea of balance of government. You have the monarchy, you have the aristocracy, and you have the common people. And those are the three segments of society that provide balance and prevent tyranny. The Americans changed that to replace a socially class-based division on one based on function. You have a House, a Congress, a president, and a Supreme Court, which all have differentiating powers and all serve to check excesses by the other. That's the essence of the theory behind divided government in the United States. And that's why the idea of German democracy does not acknowledge a status of divided government that way. And America does. So I think there's a lot of differences. And yes, America is different than Europe. Anything else? I've got time for one more. It's 20 minutes after 12. I'm sure we're all hungry. I'll take one more.
You know, I'm thinking about all of the elected people who then they've managed to execute a coup, and what happens is first the opposition political leaders go to jail, and then the journalists go to jail. And I mean, how does that happen? What is the mechanism for that to happen? And does this open the door to that mechanism?
Yes, I think this does open the door to this, and I will take you back to my closing line from H.L. Mencken. We get the government we deserve. And what happened in Germany is all the good people turned around and said, okay. They went along with it because democracy hadn't really worked in Germany to the extent that the German economy, until Hitler came to power, sucked. And for a lot of different reasons, some of which had nothing to do with democracy, some of which had to do with unequal wealth distribution and bad policy, the holdovers from tariff policies. But the bottom line is that the majority of Germans looked the other way and went along because he cloaked it in law. Reichstag said this applies. Reichstag says that applies. Reichstag says I get to decide. I am your Führer, and he got the army to take an oath of loyalty to him. German went along with it. That could happen here. What's his name? Sinclair Lewis wrote a book called "It Can Happen Here." Okay, thank you all.